All right, here we go. First thing we're going to talk about, and you notice at the bottom right, I'll have remember that just comes straight off of what I told you. Chapter 6, violation of licensing law, penalties and procedures. And there's two questions that are coming from that chapter. That's Unit 6. Okay, so here's what we're going to talk about: administrative penalties. You got to know these. And so it's just a matter of resting your eyes on these and just getting to where you know what these administrative penalties are. These are issued, by the Florida Real Estate Commission. Remember, Florida Real Estate Commission is what's known as a quasi-legislative and a quasi-judicial organization because they're not the real legal system or the real legislation. They can't put a licensee in prison. They can only administer penalties and fines to them. Okay. And so you want to know these. Okay. So application denial, if they're going to deny an application, the applicant has 21 days to request a hearing. The letter of reprimand, if you see that on the state exam, that's the least severe. It's usually a first-time offense. It's just a letter of reprimand. Could be for, an advertising violation or something very minor that gets turned in as a complaint. Remember, anybody can file a complaint in writing, and you can actually go online with DBPR, and there's complaint forms that you can file. Anybody, licensee, non-licensee, anybody can file a complaint, but it's got to be in violation of the licensing law, okay, or 61J2. And so the least severe of all the penalties is called a letter of reprimand. And that kind of makes sense. Everybody kind of understands if anybody gets a letter of reprimand for something, it's usually a first-time offense. Don't do it again. Maximum 10-year suspension. Okay, that's the law. FREC can only suspend you or suspend the licensee for a maximum of 10 years. You got to know that number. Now, they can revoke a license, and that's permanently. There's also another term called revoke without prejudice, okay, or revocation without prejudice. And what that means is without prejudice means there was no complaint filed, there was nothing wrong that the licensee did, but the Florida Real Estate Commission issued a license that may have had wrong information on it. Could have been a wrong legal name, whatever information it has. So what they have to do is revoke it to reissue another license, okay? So it's without prejudice. There's no complaint, no penalties or anything like that. Your citation ranges is from 100 to 500. Okay, those are citations. Those are issued by DBPR and the DRE investigator. They range from 100 to 500. And you have 30 days to pay the citation or file an objection to the violation. Okay, so if a citation is issued by DBPR for whatever cause, you got 30 days to pay the citation or object to it. And the range they can carry that citation is $100 to $500. Okay. And then the Florida Real Estate Commission can, for more serious violations, can impose fines up to $5,000 per violation. Okay. Per violation. So there's two charges. It could be 10,000, 3, 15, and so on. Okay. They can impose probation, the Florida Real Estate Commission, which means they can make a licensee attend monthly meetings. And then DBPR for a first minor violation, 15 days to correct the action is an issue notice of noncompliance. Okay. An issue notice of noncompliance, okay, is not a letter of reprimand. An issue notice of noncompliance, is that what it means? Noncompliance. Someone could have ran a marketing ad for some reason, and it wasn't in compliance with the proper disclosures, for example. So DBPR can issue a notice of noncompliance, which is basically a 15 days. You have to correct that action. Okay, 15 days. So you want to pay attention to these administrative penalties. You may see a few of them on the state exam, but the ones we're concentrating on are the citations, the suspension, 10 years, revoke, citations, 100, 300, 30 days to correct the citation. The fines are $5,000 per violation. Okay. All right. The question may read, a sales associate was issued a citation. How many days does a licensee have to either pay the citation or file an objection to the alleged violation? Okay. That's a good answer, Amanda. Good. Whitney? Perfect. Excellent. Remember, The citation range 100 to 500, and the licensee has 30 days to correct the violation. Okay, 30 days to pay the citation, in other words. All right, so we're talking about answer C. Answer C. Very good. All right, let's talk about applicant disclosure requirements. Okay, now when we talk about applicant, that's the position you're in right now. Okay, as an applicant, the background check consists of any type of history of the applicant other than moving violations. Okay, so anything that was considered to be under investigation, anything that was a conviction or enter a plea of guilty. It could be a federal crime. It could be a misdemeanor penalty, and it can happen at any time and anywhere. Okay. They also do background checks for aliases. Okay, which are other names than their legal name. If a licensee was disciplined in another jurisdiction, we get a lot of licensees that come into the state and they go for their broker test, right? They're studying for their broker test. Or they just want to do the sales associate. Remember, Florida is not a reciprocity state. And so when you come into Florida, besides other few exemptions, if you come into the state of Florida and you're licensed in another state, they don't do a reciprocity agreement where you just fill out an application. So you have to go through the background check. You have to do everything that a normal licensee or an applicant would have to do. And so if they were disciplined in another jurisdiction, okay, that's going to be also investigated during the background check. Any suspension or revocation of a license from a licensee that's applying, okay? And it's also required that everybody gets fingerprinted too as well, okay? So background checks for the applicants, very, very important that you understand it consists of a lot of these that will be done through the background check, through the applicant disclosure requirements. In other words, what you have to reveal. All right, which information must be disclosed on the license application? Which information must be disclosed? Okay, excellent. All right, so let's go back here real quick. Remember, when you're talking about an applicant and an application, think about it. You want to do a background check on somebody. You're going to try to find out if there was any investigation due to any incarceration or arrest or conviction, a plea of guilty, whether it's a federal crime or it's a misdemeanor. Any aliases or other names that they could have been under of this applicant. If they were licensed, are they disciplined in another jurisdiction? Have they been suspended or revoked? And obviously everybody gets fingerprinted. So all these requirements the DBPR will do as far as a background check. And they're checking, that's what they're checking. They're checking the background of the applicant. Okay. Now, what's not on here and what DBPR really doesn't really care about, remember it says other than moving violations, but you're talking about, it says a credit history. They're not worried about their financial credit history. They're not worried about moving violation or speeding tickets if they file bankruptcy. What they're really concentrating on is their background, if there's any criminal activity, okay? Or again, any suspensions, revocations, any penalties in other jurisdictions. So that's what they're looking for. Any alias names that they may have committed crimes under. But as far as the personal credit history, speeding tickets, they don't care about moving violations. They don't care about bankruptcy credit history. They want to know what type of criminal background history that the applicant may have. Okay, so which information must be disclosed? We're talking about answer A. Okay, answer A.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, how to pass the real estate exam without your real estate book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.
Now, let me just give you a little technique. I told you I was going to teach you a little bit about how I take these tests. Okay. So if I'm reading this question, first thing I say, which information must be disclosed? That word must is in caps. There's a reason it's there. Okay. Which information must be disclosed on the license application? So the first thing I'm going to do is I know from my studies what's the requirement of an applicant when it comes to a background check, because we're talking about disclosed, right? This is a background check for an applicant, disclosed. So before I look at my answers, I'm in the test center. Of course, I'm not going to be talking out loud, but I'm going to be saying to myself, I'm going to go over the different requirements that DBPR is going to require me to fill out as an applicant. Okay, so they can research my history. And I may even review what's not required. Okay, because I know this information from my studies. And so what I try to do now, listen to me carefully, I try to answer the question before I look for my answers. It gives me a little bit more confidence going through my selection. And it gives me an actual kind of a heads up, and it makes me look and concentrate and pinpoint when I'm kind of reciting to myself. Plus, and here's the big reason. Here's the biggest reason. If I do that for every question, it allocates a continuous time. It's continuity of time per question I'm spending on. And I'm not doing the cardio, machine diagram up and down, taking a long time on one question, boom, answer the question real quick. It gives me consistency through the test. It keeps me regulated. It keeps me on cruise control, and I'm not pumping the brakes. And it gives me a lot more comfort going through the exam. Okay, that's just testmanship. That's just what I've developed over the years. And I like that because I've got continuity when I go through. I'm answering each question the same way. I'm reading it twice. I try to answer it, before I look at my answers best I can. Okay, I just kind of talk it out under my breath on what I'm looking for. Okay, so we're talking about answer A here. All right, probable cause panel, or you may see on the state exam PCB panel. Let's talk about this for a second. What is the probable cause panel? So the probable cause panel is a two-member organization. It's comprised of two members, and it's kind of an intermediate stop, or what you might call a safety net to the DBPR, DRE investigation. Instead of them, it's kind of a balance of powers, if you want to sort of speak, right? You're familiar with the civil, the civil government. You've been through civics, and you see our government has a balance of powers with Congress and the Senate and the presidential and the Supreme Court. So you got a balance of powers. Same thing with the complaint system. Think of this, because remember, when the complaint is filed, listen to me carefully. Complaints filed, DBPR and DRE are going to begin this investigation. Remember, DBPR is the big conglomerate. It's the big conglomerate over all the industries in Florida requiring licensing. DRE is the division of real estate under DBPR. They assist the Florida Real Estate Commission. Okay. So during this investigation, they've got the complaint first, and they're going to file the actual complaint, or they're going to file the not file, but they're going to investigate the filed complaint. Okay. Now, this is where the actual DBPR secretary, which is a high position, okay, very high position, the DBPR secretary can file a summary suspension if it's so egregious, the act that the licensee committed, that they're going to put that license into a suspended role until the outcome. Okay. And it's got to be real egregious. Okay. Under normal complaints, if it's not an egregious act, the licensee can stay active and stay licensed, because this process can take a long time. And so only if it's an egregious act can the DBPR secretary make a decision to apply a summary suspension at the very beginning until the outcome. Okay. Which means they can't do any real estate business. Okay. Now, what would be egregious? Well, that's up to them to determine. But I guess the closest example is if an agent took a $5,000 deposit check, right? Client went under contract on a condominium they bought, they gave the agent a $5,000 deposit check. and the agent went and deposited in their personal account and went on vacation. Okay. And said, when I get back, I'm going to get my income tax check. I'll redeposit it with the broker. Big violation, obviously egregious. In that case, the summary suspension would come from the DBPR secretary, and that licensee would be suspended until the outcome of the investigation. Okay. Now, that's the first big picture step. DBPR, DRE, going to investigate. If they see a need to further step this into investigation, they forward the investigation to the PCB panel. Okay, here's your balance of powers now. So now the PCB panel is going to take from DBPR, right? They're going to take from DBPR the actual investigation and the need to investigate it further. Okay, now when you talk about the probable cause panel, it's made of 2 members. You got to know this for the state exam. One of the 2 panel members has to be an active licensed professional. Okay, has to be an active licensed professional. Okay, now 1 member has to be a current member of FREC, which is the Florida Real Estate Commission, right? The other member can be a current member of FREC, but also can be a former commission member. Now, if they're a former commission member, they have to be active if they're called back to operate under the PCB panel. And if you think about it, we've got 7 members. All the complaints that go on in Florida, that would tie up a lot of the commission members if they had to operate under a PCB panel. And so what they can do is the state allows, the revised statute or the 475 allows for active former commission members to come back in and operate only under the PCB panel, but they have to be active, okay, in order to sit that role. So DBPR forwards it to the PCB panel, 2 members. 1 member's got to be a current FREC member. The other member can be a former member, but they must be active. Okay. So the question may read, which statement is false regarding the probable cause panel? Before you go into this, let me explain to you how I do true false. So you can review again under your breath about the probable cause panel, what it consists of, what the role of it is, etc., which is nice because that'll help you look for an answer. But when you're dealing with true false, I actually take each answer and turn it into a question. And here I'm looking for 1 false statement and 3 true statements. So I've got that set up beforehand before I start reading each answer as a question. I'm looking for 1 false and 3 true. So which statement is false regarding the probable cause panel? Okay, good. We got a few mixed answers here. We got a lot of people coming in with some mixed answers, which is this is what we're here for. Now, listen to me carefully. If you go through and turn each question into each answer into a question, it's going to take you a little bit longer to answer. Okay. So I had some answers go up pretty quick. So try to start practicing a little bit of continuity in your answer selection. Okay. So again, which statement is false regarding the probable cause panel? I'm going to kind of go through my head mentally of what the probable cause panel is. And then my last thing I'm going to do, I'm going to say, look, I'm looking for 1 false and 3 true answers. So my first answer is, I'm going to make this a question. A consumer member may serve on the probable cause panel. And the answer is true. Remember, any current commission member, out of the 2, 1 of them has to be an active licensee though. But a current consumer member, as long as they're an active commission member, can serve on the PCB panel. Okay. Number 2, B, at least 1 member must be a professional member. That's what we're talking about. Absolutely. That's true. The Florida Real Estate Commission chairperson appoints the probable cause panel. That's true as well. And the last one says A former commission with an inactive real estate license may serve on the panel. And we know from our studies, if we're going to use a former member, what do they have to be? They have to be active. So that's a false statement. They cannot serve on the panel as an inactive real estate licensee. If they're active, the former commissioner can serve as a PCB panel member. Okay. So we're talking about answer D. Okay. Again, when you go through these, set them up as individual questions and answer each question true or false. And this is where you have to know about the PCB panel. Okay. And we know in our studies that a former commission member has to be active in order to serve. Okay. So we're talking about answer D. All right. All right. Let's talk about single agent relationship. So this comes out of chapter 4, unit 4, which is authorized relationships, duties, and disclosures. 7 questions. This is a pretty big section that you want to be familiar with. Okay. Now, let's just talk about a little bit about single agent. Remember, in Florida, you are automatically a transaction broker. Okay. There is no requirement to disclose that. It's an automatic, if you want to call it an automatic relation with your, at that time, is going to be a customer. So you're automatically a transaction broker. In order to become a single agent broker or a single agent relation, you've got to disclose in writing. Okay. You have to disclose in writing a single agent form. You'll have access to all these forms when you get to your brokerage firm. You're going to join NAR and you're going to be a member of the Florida Association of Realtors. They got all these forms in your brokerage unit. Okay. So automatically you're a transaction broker, which means they're a customer. You're in a non-fiduciary role. In order to become a fiduciary or in order to become a single agent relation, you have to give them the form single agent relation. It's a single agent relation form that explains all your duties. Okay. As a single agent. Again, those are all pre-printed. It's not required to be signed. You just got to disclose. And then you now, and if it's an acceptance, you become a single agent relation with your now not customer, but client. Okay. So from transaction broker, they're a customer, non-fiduciary. You're just a transaction broker. You give them the single agent form. Now you become a single agent to them with a fiduciary role. Okay. So the time to make this disclosure is before, at the time of entering a listing agreement or buyer agreement, before showing the property. Remember, principal and client are going to be now who they are to you as a single agent. As a transaction broker and a no brokerage, they're customers. Okay. Now, what does single agency mean? It's a fiduciary representation that you have to a buyer or seller. You're working for one person. Now, I'm going to ask you a true false question here. Okay, I'm going to ask you a true false question. Is dual agent, listen to me carefully now, listen to my question. Is dual agency allowed in the state of Florida? True or false? Is dual agency allowed? Okay. Is dual agency allowed? Okay, I got all false answer, but I got one true answer, which means someone is saying dual agency is allowed. If dual agency is allowed, under what conditions can you be a dual agent? Is there ever a time you can be a dual agent? Is there ever a time you can be a dual agent in Florida? What would that be under? From your studies, when can you be a dual agent? Right? When can you be a dual agent? Remember, under the law of designated agency, when you're dealing with commercial property, remember the client has to have $1 million in assets. They have to request dual agency. You can be a dual agent under a designated agency, which is in commercial, and that's requested. Okay, so go review that. What you want to pay attention to in the question is dual agency is not allowed in Florida under residential sales. Okay. When you're dealing with residential sales, dual agency is not allowed. You're absolutely correct. But in all cases, if it's a general statement that says, is dual agency allowed in Florida? And it says, well, it depends. Are you selling a home, condo, land, residential, or are you selling commercial property? Because under the law, commercial property, you can act as a designated agent and actually be a dual agent to a buyer and seller, okay, upon their request. Remember, they got to have $1 million in assets, the clients do. So go review that, okay? Very important that you understand that, because if the test question doesn't really designate it, you got to be careful, because that's how Pearson VUE can hook you and trick you on that. Okay, so let's go back to residential. You are absolutely right when you say no dual agency under residential. You're absolutely right. Okay, so what does single agency mean? It's the fiduciary representation to either the buyer or seller. Now, this term special agent is a term that you're going to see under agency relation that deals specifically, okay, specifically the duties of a single agent. Okay, it's called a special agent. In other words, a listing agreement. I'm going to execute and buy and sell a home for you. A buyer's agreement. I've got a single responsibility to find you a home. Okay, it's not what's known as universal agent or a general agent, but we're calling it a special agent. Okay, a special agent has to deal with a specific duty that you're doing as a single agent for a seller or a buyer. Okay, so the question may read, a real estate broker, when working in a single agent relationship, there's my key word right there, is typically authorized by a principal to act as what? Okay. Excellent. That's right. We're talking about a special agent, right? That's what special agent is defined. You're executing a single fiduciary responsibility to your client. Okay. So we're talking about answer D. Very good. That's awesome. Good job. All right. We're going to go into our first tax problem. Now, don't let this, the reason I got this slide all prettied up, I mean, I'm not, you don't want to go to your scratch paper on the exam and draw this out like this, obviously. But you do need to develop a system on how you're going to, I call it, listen to this, I call it unpacking my numbers. How many of y'all been on vacation and you get to your destination, you got to unpack and then, you get home and you got to unpack, there's a little method to that madness to where you don't get frustrated and start throwing clothes everywhere. So you got to really organize and categorize your numbers that you know where you're going in your calculations. Okay. So this is what I'm calling organization and on how to unpack your numbers. Okay. Now, in the actual tax problems, you're looking for some key words. Remember, you got to concentrate on the homestead exemption. Okay. So you need to look for stuff like a widow, a blind, disabled, or maybe a blind widow. Remember, each one of those yields $5,000 in addition, extra exemptions. So a blind widow is $5,000 each. Watch that for the test question. We don't have it here. I may have one later. We don't have one in this, but you got to watch for the verbiage, because if you read it too quick, you're only going to see one exemption in a blind widow. And there's two, one for blind and one for being a widow. Okay, so watch. Those are the trick questions I'm telling you about. All right, so here we go. A home has been assessed by the county appraiser for $116,000. The property is homesteaded. The city, county, and school board each charge 10 mills for a total of 30 mills. Now stop there. Why do they need 30 mills there? And the reason they put that there is to throw you off, because now you got to think, I got to use the number 30 in this problem to calculate. And that's what they're banking on you doing. But all you need to know is that the county, school, the city, county, and school each have 10 mills. Okay. Forget the 30. 30 means nothing other than being there to try to lure you in. I'll show you what I'm talking about. Then they're asking how much is saved by the homestead exemption. So you got to work this problem out twice. You got to work it out with exemptions and you got to work it without exemptions. And then you got to subtract the difference to get your answer. Okay. So let's go with exemptions. Okay. With exemptions. So if you look at the first, if you look at my box, the way I unpack these, I put city and county, always put city and county together. Okay. They get a base of 25,000 and then they get another exemption of 25,000 if the assessed value is above 75,000. In this case, it's 116. So 25 and 25, the city, county get 50. Remember, 10 each is 10 plus 10. They get 20 mills for the city, county, and then the school only gets 10. There's your 30. Okay. But 30 has nothing to do with this problem. Now, if I take city, county, which is 116,000, my appraised value or my assessed value, minus 50, that's 25 plus 25. Okay. It gives me 66,000. Notice I don't have any blind. I don't have any widows. I don't have any disabled. So there's no additional exemption. So it's just a straightforward base 25, another 25 for above 75,000 assessed. Add them together. I get 50. So 116,000 minus 50. So actually my homestead exempt assessed value is 66,000. And then I want to multiply it times my millage. Okay. My millage is converted by dividing that number by 1,000. That'll give you the decimal, or move it 3 places to the left and put a decimal. Okay. 1 mil by definition is 1/1000th of a dollar in the tax assessment world. Okay. So if I take 20 divided by 1,000, I get 0.02 times 66, $1,320. That's the tax on this property for the city, county. School, again, 116 minus only 25 base gives me 91. 10 mills, 0.01, 910. I add them together, $2,230 is the tax I'm paying after homestead exemption. After homestead exemption. Now I need to know what the taxes are if there is no homestead exemption, because they're asking me how much is saved by having homestead exemption. So I'm just going to do a straight calculation with no exemptions, which is 116,000 times 0.02. That's 20 mills, which gives me 2,320. And then I'm going to go for my school. 116,000 times 0.01 is 1,160. If I add those together, I get 3,480. That's before exemptions. After the exemption, and you can look at exemptions as what's called discounts, right? Everybody likes a discount, right? Everybody likes a discount. My wife tells me, I got it 60% off. I said, okay. So she bought, 100 of them. But anyway, discounts is all this is. This is all this is. They call it exemptions, but it's just discounting is all it's doing. So you're calculating one before exemption or discounting with the discount or exemption, and one without. You don't get any discount. And you're just going to subtract the two. So the savings is $1,250. Okay. Everybody good here? Give me a thumbs up or yes, and we're going to move forward. Everybody good here? So we're saving $1,250. Listen, be careful with this, because guess what answer they're going to have? They're going to have 2230 as an answer. They're going to have 3480 as an answer. My whole point of it is you got to work 2 problems out and subtract them to get the correct answer. They're going to put these 2 answers in there along with the right one we just figured out, because they know if you read it too fast. Listen, this is what we do. This is just the humanism in us. When we read, we don't comprehend a lot of times what we read, what they're asking. because you start out, okay, you got an appraisal problem. You don't even read the question. You start unpacking numbers. Okay, 116,000. Okay, let's see, city, county, 10 mills each. So that's 20 mills for city, county, 10 for the school board. Okay, and they're asking, okay, what's the tax on it? You don't even read what you're asking, and you figure out a tax based on the exemption, and you come up with 2230. And guess what they're going to have for an answer? 2230. This is part of the test question analysis. You got to slow down. You got to read these questions, and you've got to ask yourself, how much is saved by homestead exemption? Okay, in order for me to see how much I'm saving, I got to figure out how much tax is when there is no homestead exemption. And when there is, the difference between those is how much I'm saving. And you can see how easy it is for you to read this quickly and just figure out a normal tax problem, and they're going to have that answer there for you. Okay, so I bring that light to you. Okay, be ready for those type of questions. All right, moving on. Going back to application requirements. Now, I told you earlier that Florida does not have what's called reciprocity agreement. Okay, and that's true to an extent. Okay, there is, under what's called the Occupational Opportunity Act. What does reciprocity agreement mean? Well, that means if it was possible, if I lived in Georgia and I bordered Florida, that means I could go into Florida as a licensee from Georgia. I could apply for a license and just complete the application and get licensed in Florida. That's called reciprocity. They agree one another. Florida can do the same thing with Georgia. Florida does not hold any reciprocity agreements with any other state at all. Okay. We have what's called mutual recognition with a handful of states, and that's a whole different lesson plan. But reciprocity, when it comes to just completing the application, Florida does not have that with any other state under normal conditions. Now, Florida is a big military state. So what they do execute is what's called the Occupational Opportunity Act. And this is a reciprocity agreement for armed forces that are active and their spouses or surviving spouses. Okay. They got to hold a license and be in good standing in any other state. Okay. So let's say, for example, I was at Shepherd Air Force Base in Texas, Wichita Falls. That was my last duty station before I got out. If my wife was licensed in Texas, Texas only, I'm not licensed. I'm just active duty military. And we were getting out. I was exiting the Air Force, and I was moving and relocating to Florida. Okay, that's where I was going to move to as a civilian. I'm getting out of the Air Force. She's licensed in Texas. I'm active duty, right? I'm in good standing, honorable discharge. Watch this. And here's the big thing about it. She does not have to be active duty. While I'm active in Shepherd, before getting out, while I'm active as a licensee in Texas, she has a reciprocity agreement with Florida if she wanted to complete the application process and get her license. Okay. It's only good for armed forces, active and former spouses or surviving spouses. Okay. It's called the Reciprocity Agreement, Occupational Opportunity Act. Other than that, there is no reciprocity agreement with any other state. Okay. Only what's called a mutual recognition program. I think there's about 10 states involved. You don't need to know the 10 states. But it's all they have to do if they're in a mutual recognition state, all they have to do is take a 40-question test that Florida has. Okay. But under the reciprocity agreement, again, unless it's military and they're licensed and in good standing, they don't have an agreement with anybody. Okay. So the question may read, a member of the U.S. Armed Forces is transferred to active duty in Jacksonville, Florida. The service member's spouse holds a valid New York real estate license. The service member's spouse desires a Florida real estate license. Which statement is true? Which statement is true? Okay. Here's another example, true, false. I'm looking for 1 true and 3 false. And as I'm reviewing, I see that a member of the armed forces is transferred to active duty in Jacksonville. The service member's spouse has a New York valid license. So, and they want to get licensed in Florida. They're active duty. They're just relocating to a new base. The spouse is licensed in Florida. All she has to do is fill out paperwork and she gets her license. There is no mutual recognition program for that. It's just simply, I'm reviewing this in my head, right? And then I'm looking for my 1 true and 3 false, right? Upon application, answer A, upon application for a license, the DBPR must issue the spouse a Florida real estate license. That's a true statement. The spouse is eligible for a Florida license provided Florida has a mutual recognition. That's false. This is not mutual recognition. This is armed forces, active duty, or spouse transferring, is licensed, has to be licensed in another state and in good standing. All they got to do is complete the application. Okay. The spouse must pass the Florida real estate exam. No, the spouse must complete the pre-license education, and that's false too. So all the spouse has to do is complete an application to get her license. That's it. As easy as that. But you got ties to that. Their spouse has to be active duty, good standing, and the spouse has to be, in this case, licensed in another state in good standing. Okay. All right. That's the only time reciprocity agreement is allowed. Other than that, you can be licensed in any other state. You cannot have a reciprocity agreement. There is a mutual recognition program out there that is similar to Florida's education and testing requirements, and those states are allowed to take a 40-question test and become licensed. All right, let's move on. Management of an escrow account. Very, very important section here. This comes out of Unit 5, Real Estate Brokerage Activity and Procedures. You got 12 questions, okay? Now, a couple of terms you want to know. You want to know, and I'm just going to kind of pick these out that are real important for the state exam. You want to know commingling and conversion, C and D. Commingling is mixing, right? Conversion is when you use it to cover expenses, for example, okay? In the escrow account, for the sales escrow account, this is the broker's account, by the way. This isn't a sales, this is only for the broker. For a sales escrow account, the broker can keep a maximum of $1,000 of personal money in there. Property management, $5,000 is the maximum of personal money. You say, well, John, I thought we couldn't keep. That would be commingling. No, the law says the broker can keep $1,000 of personal money and $5,000 of personal money in these escrow accounts to manage them. The last thing you want to do is use somebody's deposit to pay an account fee. That would be a violation of licensing law. So the broker has to have personal money in the account to maintain the account. The restriction is $1,000 for sales and $5,000 for property management. If they're using one account to do both services, they can have $5,000. Okay. Now, record keeping is 5 years. If the title company is going to keep the deposit, they have to have their name, address, and telephone number of the attorney or title company on the agreement. Okay. Now, you got 2 types of accounts. You got non-bearing interest account and interest-bearing accounts. Okay. Non-bearing interest accounts or non-interest bearing are typical for real estate transactions, right? It's just like burying it in the backyard. It's an account that doesn't do anything but hold money until the closing. It's the buyer's deposit, and that's where it goes. The broker holds that deposit, okay, in their escrow account. They can have an interest-bearing account, okay? But if money is going to be moved, listen to me carefully. If they're going to move money from a non-bearing interest account to a bearing interest account, all parties have to agree in writing. Okay. Two types of accounts: non-bearing interest, which means it don't earn interest. Bearing interest means it can earn interest. So, well, John, why would you want to have a bearing interest account when the real estate transaction is only 30 days and it's a $2,000? How much interest are you going to collect? That's a good point. And typically residential, everything gets deposited into a non-bearing interest account. But interest-bearing account can come, say, in a commercial deal where you got a $3 million building that's being sold. It's going to take a year and a half. Now you got a different story if you're collecting a $30,000 down payment. Okay. But the point for the state exam is, if you're going to move money or move funds from a non-bearing interest to a bearing interest, all parties need to know in writing. Okay. All right. Which statement is true regarding a real estate broker who provides property management services? What do you think? Which statement is true? Okay. Again, if you go through this and you're looking for one true and three false, right? Looking for one true and three false, talking about property management services. So it's kind of a generic question. So I don't have any answers I can come up with, but I'm going to read the questions. I'm going to read each answer and convert it to a question. So brokers are allowed to keep up to $5,000 of personal in a PM escrow account, property management. And I know that to be true. So my first answer is true, but I'm going to make sure. Sales associates are allowed by law to independently provide property management services to absentee owners as extra income. That's false. Brokers required to maintain a separate property management escrow account. No. Brokers may post a bond with the county court in lieu of. No. These other answers usually come under the Florida Landlord and Tenant Act. Okay. When a landlord has laws, they have to keep escrow money like security deposit and rents. But what we know from our studies here is the maximum for a property management account is $5,000. Okay. So we're talking about answer A. Very good. Looks like everybody's on board there. Perfect. All right. Back to Brokerage Relationship Disclosure Act. Now, in chapter 4, you got 7 questions here. What you have here in this slide is what does 475 define as residential property? Remember, we said that you can only perform single agency in residential properties and not dual agency. Okay. Dual agency is allowed under the designated agency law with commercial property, but not in residential. Well, what do we define as residential? Well, here's 475's definition of residential sales. Residential improvement. Improvement means house or building. Okay. Could be a fourplex, a condo, whatever. Residential improvements up to 4 units. Okay. Single family, duplex, triplex, fourplex. Land zoned for up to 4 units of new construction. So raw land, but it's got to be zoned residential for up to 4 units. And then property zoned for agriculture of 10 acres or less. That comes under the definition of residential sales. Okay. And that's going to apply with you and whoever you're dealing with as a transaction broker, a single agent broker, or a no brokerage. Okay. Those 3 entities apply to residential sales, along with no dual agency in any of these properties that are defined by Florida Statute 475 as residential sales. Okay. Now, we do have some exemptions when it comes to that, right? We do have exemptions when it comes to disclosure requirements. In other words, your transaction, your single agent, your no brokerage. So here are the exemptions, right? Non-residential transactions, we talked about that. Commercial, there is no agency disclosure requirements for that. If you're doing a lease, okay, unless it's an option, which is a purchase agreement with an exercise date, rents or lease are exempt from agency disclosure requirements. Business opportunities, unless it's 4 or less residential units. If it's a business and it has to do with leasing property up to 4 units, then it's exempt if it's not included in that. Auctions, appraisals. So you want to know a few of these. The big ones you want to know is non-residential or commercial transactions, rent or lease. Those are exempt from agency disclosure. Otherwise, when you're dealing with residential sales, you have to know by definition what they define that as. Okay. Improvements up to 4 units. Land zoned for up to 4 units for improved construction. Improvement construction. And then property zone for 10 acres or less. Okay. All right. So the question reads, the brokerage relationship disclosure requirement in Chapter 475 Florida statutes do not apply to what? Good. Excellent. Good answer. So we know answer A, answer C, and answer D fall under the definition of residential disclosure. Okay, that's residential sales. Okay, leasing is an exemption, as we saw in our studies. Okay, so we're talking about answer B. Answer B. Good job. Excellent. All right, let's switch gears and talk a little bit about sales associate education. This comes out of Unit 2. You got 6 questions. This is a fairly big topic that they like to ask. And here's the question they like to focus on. An exemption for the sales associate education. In other words, the course, the exam, post-licensing, okay? All that's exempt if the applicant is accredited with a real estate degree or higher, master's, PhD, etc. Okay, so a 4-year degree, a master's, or a PhD. If they've come from an accredited university that's got an accredited program for real estate for a bachelor, master's, or a PhD, they're exempt from the course, exam, and post licensing, not the biannual education requirements. Okay, every 2 years you got to complete 14 hours. Okay. Remember, the sales associate course is 63 hours. You got to pass an end of the course exam, and then you got to do a state exam. Remember, when you take your end of the course exam, if you don't pass it the first time, you got to sit for 30 days and then retake it. This is with your school. This is the end of the course exam with your school. If you don't pass it the second time, you got to retake the entire program again. Okay. And in the Pearson view, you can take it as many times as you want. I guess they say the retake is 24-hour time frame. But you can take it as many times as you want. Okay. Got to have a 75. You get 3.5 hours to take the Pearson view exam. Okay. All right. Here's the big thing. When it comes to sales associate education, an accredited degree or higher, they're exempt from the course, exam, and post licensing, but not the biannual review. Okay. All right. An individual who has earned a 4-year degree or higher in real estate is not exempt from which education requirement? Good. Continuing education. Talking about answer B. Beautiful. Excellent. All right. Let's talk about the recovery fund. This comes out of chapter 6. 2 questions. This is a big topic here. Remember, the real estate recovery fund is kind of a safety net for licensees. Okay. In the event they get sued, they got to be, first of all, it's got to be a complaint, from the civil side of things. It's got to be a violation of 475. It's got to be violation of 61J2. And basically what happens is the consumer's been injured in a transaction, okay? Suffered monetary losses, okay? And so they file a complaint, and then the licensee has to try to attempt to pay for it himself or herself, okay? Out of their own personal funds. If they can't, and they can't have, and of course their E&O insurance would kick in, which is what you're going to be applying for when you get errors of omission. You'll be applying for that insurance. But personal funds and E&O insurance, if that doesn't cover the actual monetized suffering of what you're being sued for, or actually what your client is suing you for, then you can go into the recovery fund for the remaining portion, okay? The licensee, here's what you want to know, is suspended until the recovery fund is repaid, okay? So you are suspended. The licensee is suspended until that's repaid, okay? Now, the payments from the actual recovery fund is $50,000 per claim, okay? And depends on the number of claimants. The total payment cannot exceed an aggregate of $150,000, okay? The licensee has to be active at the time the act was committed, okay? The licensee cannot be acting as a principal owner. In other words, they're not selling their home, or they're not acting as a purchaser or a principal, okay? They don't get any access to the recovery fund. If they're own the property, and they got to be licensed, they got to be active. And they can't, the licensee cannot represent a spouse in a transaction and expect to use the recovery fund too as well. Okay. So the big things about the payments from the recovery fund, $50,000 per claim, regardless of the number of claimants. If there's 4 people suing, there's 1 claim, then it's going to be that number divided by 4. Each of them get that much. So not each of them get 50,000. Okay. And then the total cannot exceed 150,000. All right, the maximum payment from the real estate recovery fund for a judgment issued in connection with a single real estate transaction is what? Yeah, this is kind of a little bit of a test question that's not really clear. Remember, it's 50,000 per claim regardless. Okay. So I guess the terminology you're looking for is the word claim versus aggregate. Okay. So the maximum payment from the recovery fund for a judgment. 1. Remember, these key words you're looking for are very important that you read this, because it can be confusing. You can see they have a couple of correct answers. 50,000 and 150 is what we're looking for. But it's the wording that's going to be the difference in this. And so we see the maximum payment from the recovery for a judgment, which means one judgment. Okay. 1 judgment is going to be 50,000. Okay. Again, regardless of how many people are making the claim per transaction. And so a judgment, it represents per transaction. So you got to be careful. This is one of the testmanships that I'm trying to teach you on these test question analysis. You got to slow down a little bit, and you got to analyze it. This is why I like to read the question 2 times. Okay. And then I go back and look for keywords. Maximum payment. Okay. So I know the maximum payment per transaction is 50,000. I'm reviewing this. in aggregate, which means total I can use from the recovery fund is only 150,000. So there may be another lawsuit down the road. So that adds up to be 150 is my total aggregate. But the maximum payment per transaction. So knowing that, I'm looking for keywords again. The maximum payment from a real estate recovery fund for a judgment. So I'm thinking a judgment is one payment, one transaction. So my best selection would be answer C, 50,000. Okay. Very important that you do this. Develop a system. I'm telling you, it's going to work for you. You got 3.5 hours to take 100 questions. Develop a system where you're reading these questions twice. Look for keywords. Okay. Look for keywords and know that they're going to have, if you see two answers you recognize, like 50 and 150,000, you better go back and make sure the wording's right, because there's two of the correct answers are there, but only one of them is the correct answer. Does that make sense? Everybody good? All right.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.
All right, here we go. Let's go back to another calculation of a property tax. All right, same thing, nothing different. I'm going to read the question and I'm going to ask, what are they looking for? Okay. A homesteaded property located in Florida, city tax rate 8.2, county 8.9. So I got two mills I got to add together. School tax 6.2, district, the rate is 6.2. Homeowner is a widower. There's a key word I need to keep in because that's an exemption, and has qualified for homestead exemption. The home is assessed for $192,900. What are the property taxes due? Now, here's a simple question. What are the taxes due on this property? Not how much I'm going to save. What are the property taxes due? So this is just a straightforward. And all I got to do is break it out. I see that my assessed value is above 75,000. So my city, county get 25 base plus another 25 for being above 75,000 assessed. So that's 50,000 total. Is one exemption, one discount. The other one is a widower, which is another 5,000. So if you come down to line 1, you can see 192,900 minus 50 minus 5. So I end up with a homestead exemption of 137,900. Now I got to get my mills 8.2 and 8.9. I add those together, I get 17.1 divided by 1,000, or move it 3 places to the left, be times 0.0171, which gives me 2358.09. Okay. School tax, no difference, except I only got a base, but I still got to include another 5,000 for a widow. Okay. So 192.9 minus 25 minus 5 gives me 162.9. Here I only got 6.2 mills for the school, so that's going to be 0.0062. I'm moving it 3 places to the left, and I get 1,009.98. And I just add them together, city, county, and school tax, and my total tax for this property is $3,368.07. So we're looking at answer C. Again, get a system, watch the verbiage, widower. They could say a blind widow. There's 2 $5,000 exemptions, a total of 10. So you got to look for keywords there. Okay. Again, read the question on what they're asking. But it's a real, once you get a system on how to do this, and you start practicing, and you're learning how to read these questions, and you're learning how to read it twice, look for keywords, you're going to get you're going to find yourself on cruise control through the whole test. Next thing you know, you're going to turn it in, look at your watch, and you're going to be about 3 hours. I've been teaching for 15 years. I've had students come back to me, second time for private tutoring. They missed it by 2 or 3 points. That's it. 1 point, 2 points. And I guarantee you I could find 10 questions they missed was due to they didn't read the question, because they know the content. This is where I would say personally, this is just John saying this, I bet 80% plus that don't make it through the first time, it's because they don't know how to read the question. And they assume, or they jump to conclusions, or they read it too fast. Okay. So it's very important that you develop a system. Again, read these questions very methodically. Pick out your keywords. All right. Let's talk about sales and leasing when it comes to broker and owner developer. This is a good topic here. This is a topic they like to ask questions on. Now, as a sales associate, which you're going to become, you're going to work for a broker. You're going to be compensated for real estate activities, and your payment's going to come from a broker. You're going to get paid a commission. Okay. If you decide to hang your license under an owner developer, which you can, if you decide that, the owner developer is considered a non-licensee. They don't have a real estate license. An owner developer must register with DBPR, okay? But they are unlicensed. Now, they could have a staff. You could be in the same bullpen with an owner developer staff that's on salary, that doesn't have a license, that does everything that you do, only for the owner developer's properties. But you get to get paid a commission for your work. They can only get a salary, okay? But the owner developer is a non-licensee. They're not licensed, but they must register as an owner developer with DBPR. They can pay their non-licensee staff a salary, but they'll pay you a commission, okay? And that's the big difference between you and a non-licensee staff, is you get commission and they get a salary, okay? You get bonuses. If you see any test questions that deal with real estate activity and getting paid, being licensed versus unlicensed, if you see anything that deals with bonuses, anything like that, kickbacks, referrals, anything that deals with money that doesn't come on a regular basis like a salary, you got to be licensed to receive that. They like to use trick words like that. Year-end bonus. Owner developer gives a year-end bonus to his sales staff, everybody, including non-licensee. Can they do that? The answer is no. Bonuses are based on productivity. Okay? They can only receive a salary. If they make $2,000 a month, then $24,000 is what they're going to pay taxes on at the end of the year. No more. It's a violation of licensing law if they get more. Okay? If you're licensed, you can get a commission. All right? But you can hang your license under each one of these. Now, you can't work for a broker during the week and an owner developer on the weekend. Only an owner developer. If you put your license with an owner developer, that's who you're going to work for. And that's it. All right. An owner developer employs 5 licensed sales associates and pays each sales associate a commission for sales of the owner developer's lot, which is true of the owner developer. There's your key words, which is true of. So they're going to ask you about the owner developer. They want to know what statement is true. What do you think? Good. That's right. The owner developer has to register with DBPR, but they do not need to be licensed. Absolutely. Good job. Looking at answer A. All right. Let's circle back. We talked about administrative penalties. Let's look at a little bit more in depth when it comes to criminal penalties and licensing reporting. Okay. Now, this is not as an applicant. Okay. Remember, as an applicant, you got to report everything. It doesn't matter when and where it took. If it was in high school, you got to report it. But now you're licensed. Okay. So now the reporting as a licensee to the Florida Real Estate Commission has to be within 30 days if it's a plea guilty or nolo contendo, misdemeanor or felony. regardless of where it took place. Remember, what we talked about before is applicant. Okay, is applicant. Here we're talking about a licensee. If a licensee is, commits a misdemeanor or felony crime, they've got 30 days to report to the real estate commission. That's within 30 days. Now, the criminal penalties, second degree misdemeanor, that's false advertising. That's going to be $500 or 60 days in jail. You want to know that. Second degree is false advertising. First degree is failing to provide an accurate or current rental list. Okay. That's 1,000 or 1 year in prison. And then a third degree felony is going to be 5,000 or up to 5 years in prison. Okay. 5,000 or 5 years in prison. And that's unlicensed activity. That's the big one. If you're getting paid a commission without having a license, you could fall under a third degree felony. Okay. All right. Which statement is true regarding a real estate associate, sales associate, who is convicted of a DUI or driving under the influence? Good. Excellent. So we're talking about answer A. The sales associate must report the DUI conviction within 30 days to the commission. So I had a question on the owner developer, the last slide. One of the questions was, if an owner developer only hires unlicensed people for a salary, do they need to still register with DBPR? And that's an answer I'm going to have to research offhand. I don't know if it's just compensation to salary employees, but I know if a commission, if a licensee works for an owner developer, they need to be registered with DBPR. So an owner developer that would not register with DBPR, and I think it goes this way, but I'll be more, and I can email you, Amanda. Just forward me your email. Email me, and I'll have your contact, and I can send you back the answer to that. But if they only have just regular staff and they're paying them a salary without a licensee, I think the association of the licensee is the reporting of, and I may be wrong on that, but that's a good question. I'll look that up for you. I've never had that question asked for me. The only thing I associate with owner developers is they got to register with DBPR and they can pay a commission and pay a salary. Okay. But I'll find out. I don't think you're going to have a question like that. I'm not saying it's not a guarantee, but it's a good one anyway. And I'll get back with you on that. Thank you. All right. Let's talk about business entities that do not need to register with DBPR. Remember, the business entities that have to register with DBPR is general partnership, is limited partnership, corporation, LLCs, okay, limited liability partnership, LLPs. The ones that do not need to register with DBPR is corporation sole, and they like to ask the question about joint venture. Joint venture is only when two licensees come together to do one single business activity, and then they're gone. Okay. So it may be a condominium, new construction, perhaps with a marina. And so a broker has experience with marina sales with condominiums, and then the other broker has condominium, and they want to come together for a single project. And when these condos are sold, boom, they go away. So it doesn't have to be registered with DBPR if it's only for a single business activity. If they form a general partnership, if they form a limited partnership or a corporation, they got to register with DBPR. Okay. So corporation sole, like church office, joint venture, business trust, co-op association, unincorporated, like HOA committees that get together and do landscaping or beautification. These are a few that you want to know. They like to ask joint venture. Joint venture seems to be, because that's usually what's typically involved with real estate brokers. They get together in one project, one business activity. Once it's done, then it's gone. So there's no need to register with DBPR. Okay. All right. A joint venture usually is created to what? Good. Excellent. Right? Carry out a single project, okay? Activity. Don't have to register that with DBPR. Very good. All right. Real estate services. This comes out of chapter 2. Now, for Florida, this is what the law says that constitutes Florida real estate activity. I like to use the acronym, a bar sale. Okay. And this is something you can just incorporate as a memory aid, a bar sale. Okay. If you're going to advertise for real estate, if you're going to buy, appraise, can a licensee appraise real estate? True or false? When you get licensed, I'm asking you this question. When you get licensed as a licensee, can you appraise property? Okay. Can you appraise property? Okay. Excellent. Okay. So you got the picture. So advertise, buy, appraise. If you're going to rent or provide rental information list, sell, auction. Got to have an auctioneer's license too, by the way. Lease or do any exchanges. Okay. Now, again, a bar sale. If you just use this memory aid and know these real estate activities, there's no other question that they can ask outside of which of the following below is or is not. Okay, so that's the type of question you're going to kind of get. In other words, which activity is not a real estate service? There you go. I'll tell you, a bar sale is really a good memory aid. I like memory aids. They're really good. Excellent. Right? Advertising, auctioning, and renting are activities. Mortgaging is not. Okay. All right. Let's talk about, again, we're going to circle back to chapter 4. This is the relationship, duty, and disclosures. We talked about single agency. We talked about transaction and no brokers. Let's do a little bit of a review again. Remember, transaction brokers, you are automatically a transaction broker when you engage in real estate activity with a customer. That's what they're going to be called, a customer. There is no disclosure required. And you want to get with your brokerage, your broker, and find out what company policy they may have in place and how you are going to approach when you start doing real estate activity when it comes to these 3 different types of agency relations. Okay, so transaction broker is automatic. In order to go to a single agent or a no brokerage, you have to just provide a disclosure in writing, and it's going to be a disclosure form, single agent broker or a no brokerage. Okay, that has to be provided to your client or your customer. Now, under transaction broker, it provides limited representation. Okay. That word limited representation under a transaction broker means you have to uphold somewhat of a confidentiality with them. Now, here's the question I'm going to ask you. Don't be tricked by this now. Can you work with a buyer and a seller as a transaction broker? Can you work with a buyer and seller as a transaction broker? Okay. So if you say, yes, I can work with a buyer or seller as a transaction broker, I thought we talked about earlier, we couldn't do dual agency in residential sales. Okay. So the only time when dual agency is not allowed is if you're holding the position of a single agent broker relation. Okay. In other words, let's say you're working with me, I'm listing my home, and you come over to my property to look at it, and you're looking at my property, and we sit down at the table and we start discussing the listing agreement, etc. Your engagement with me, touring the property and just called ministerial acts, it's just information. Okay, it's an interview. you're a transaction broker at that point. You came into my home to look at the home and to discuss the possibility of listing. We haven't engaged in any type of agency relation agreement yet. And so the law says you're automatically a transaction broker. That's where you're sitting with me. We're touring the home, talking about listing, et cetera, et cetera. So we sit down at the table, and I like the program you want that you're bringing and what kind of marketing you're going to do. So I'm going to go ahead and list my property with you. At that point, you would, if you wanted to put a fiduciary responsibility onto me, you would disclose to me in writing, which is the form. I don't need to sign it, but you would disclose to me, and I would accept, yes, I want you to be my single agent. I want you to have a single agent brokerage requirements to me, which means you cannot now be a dual agent with anyone in your firm or any other buyer that you may have. You can't do that. Okay. So now I'm a client to you. So you went from transaction broker to disclosing a form with me, and now you're in a fiduciary role to me, and I'm called a client now. I went from a customer to a client. Okay. Now, if you wanted to go from transaction broker to no brokerage, you would have to disclose that in writing. Again, I'm going from customer and I'm still maintaining a customer relation. Okay. So automatically a transaction broker to actually go to a single agent or go to a no brokerage, you must disclose in writing. Okay. Those are the forms you got to give out. Okay. No dual agency is allowed as long as you're a single agent. Okay. Or a single agent relationship. All right. All right. So the question says the broker and the seller agree to a single agent representation. So use the example I gave you. The broker must, and what is your answer? Okay. Got a couple of mixed answers. Let's go back and review. Let's go back and review real quick. Remember, automatically, use the example I'm giving you here. You show up at my listing. I invited you to come because I want to interview you for a listing. We're walking around the property. I'm pointing all the good things out, et cetera, et cetera. It's just ministerial, only information. We sit down at the dining room table. You pull out your marketing plan, and we're talking in detail about that. And then I commit to you and I want you to be my single agent. And so I want to be a client to you. I want you to have a fiduciary and work with me only, no other buyers. So you're going to give me in writing, which is the form. You're just going to disclose and say, look, here's my duties. This is a disclosure statement that's required by law. That's it. Doesn't have to be signed. Just got to disclose it to them. Okay. So the broker and the seller agree to a single agent. The only thing the broker's got to do is give the seller a single agent notice. Okay. Answer A. That's all the broker has to do. Okay. So we're talking about answer A. Give a single agent notice. Very good. All right. In chapter 5, one of the biggest sections here, right? 12 questions. Real estate brokerage activities and procedures. Okay. So we're going to go back and look at the process for disciplinary action after a complaint process. Remember, the complaint is filed. Anybody can file a complaint against the licensee. Okay. Must be in writing, and obviously it's got to be signed by DBPR. It's got to be a violation against the licensee about licensing law. So the licensee have had to violate a licensing law statute, okay, a 475 statute. Now, here's where the investigation starts. And we talked about this a little bit earlier. The complaint comes in writing. DBPR is processing it. They're going to determine what the allegation is, and then they're going to start investigating it, okay? Remember, DBPR will send a copy of the complaint to the licensee or the attorney representing the licensee, okay? So the copy of the complaint's got to go to the licensee as well. Now, here's what you have to know. Summary suspension. Summary suspension is issued by the DBPR secretary only, okay, the DBPR secretary only, when the licensee is determined to be a public danger, okay, or the complaint is so egregious that the DBPR, again, secretary is going to summary suspend or suspend temporarily until the actual process is over, complaint process is over, okay? DBPR secretary only can issue a summary suspension. Now, and we talked about this earlier when we were talking about the probable cause panel. Remember, 2-member panel. It's got to be an active current member, okay? Whether it's a broker, a sales associate, a broker associate, or a non-licensee, it's got to be a current, and it can be a former, but they got to be active. Now, one of the two has to be an active licensee, okay? All right, so sufficient complaint, then it's forwarded to the probable cause panel. So DBPR makes the decision. Remember, they could stop there and just issue the initial complaint, the first-time complaint, or they can forward it to the PCB panel to further the investigation. Remember, the PCB panel is kind of a balance of powers. Let us take a look at it now. As licensees, let us take a look at it. And if we see deemed to go forward, we'll move it forward. If not, we're going to stop it here and do what we have to do. Okay? So, sufficient complaint, DBPR says we're going to forward it to the probable cause panel. All right. If a legally sufficient complaint has been filed, investigated, and found valid, the next step in the complaint process is what? Good. Perfect. Don't forget the summary suspension. That's kind of a sidebar, okay? They like to sneak a question in there, and they'll put all kind of answers in there that make sense, but who can be the only one to suspend the licensee under investigation in the beginning of the process? And it's the DBPR secretary, and it's called the summary suspension. Okay. All right, so if a legally sufficient complaint has been filed, investigated, and found valid, the next step in the complaint process is probable cause determination. Okay. Remember, we're talking about the complaint. So this is the initial stages. It's been filed, they're investigated, DBPR investigated, and found it valid to go on and continue. They're going to forward it to the probable cause panel. Now, you can see that there's those other A, B, and C. Those are actually correct answers in the process of the formal complaint. Remember, after the probable cause panel determines it needs to go further, they will issue a formal complaint to the licensee, and the licensee has 21 days, called the election of rights, to choose to have an informal hearing or a formal hearing. Okay? And then after the determination has been made, a final order issuance is given, and then they can go in with the final order issuance, and then the licensee can go into the appeal process. Okay? Because the actual final order does not go into effect for 30 days, and that's the appeal window. So we're talking about probable cause determination. Good.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.
All right. Still kind of concentrating on the disciplinary side in the complaint process. One thing that is kind of a tricky situation that can be misleading, and I've had this question asked many times. So, John, if you're not licensed, how can you have a complaint filed at you, licensed or unlicensed? And it's part of the law. The law says licensee or unlicensed public can come in under a disciplinary action when it comes to real estate activity. It's much like an attorney practicing law without a license. It's much like a physician or a doctor practicing medicine without a license and current. They come under the law as an unlicensed public, and there's serious consequences for that. Okay. So when a complaint's filed, it can be against a licensee or unlicensed public. Let me ask you this. What if somebody is out there selling real estate, and in the process of selling real estate, they're not licensed and they're getting commission money, right? Not licensed and performing sales, selling property, representing buyers, and they're getting paid a commission, but they're not licensed. You think they should be responsible for being disciplined if they get caught? The answer is yes. In fact, that falls under a third-degree felony, right? Third-degree felony. Complaints filed, they can receive up to 5 years in prison and or $5,000 or both. Okay. So licensee or unlicensed public is responsible in a complaint, and they both can be. Okay. We talked about the summary suspension. The investigation is going to be determined by DBPR. Again, they're going to investigate the complaint as it relates to 475 or 61J2. The complaintee will get a copy, or the licensee will get a copy of the license. Remember, the first-time offender, if DBPR stops it, doesn't forward it to the PCB panel, they may issue a notice of noncompliance or a first-time violation. Summary suspension we talked about. Here's where the PCB panel, if the PCB panel finds a valid reason to forward it through the process, this is where they will issue a formal complaint to the licensee, in which the licensee has 21 days, called the election of rights, to select whether it's a formal or informal hearing. Remember, an informal hearing, they cannot defend themselves. Okay. They go to a FREC meeting and they get their penalty. A formal hearing, it's done before an administrative law judge that's been 5 years on the bar, right? They can bring counsel with them, and they can defend their complaint in a formal hearing. And then the administrative law judge will issue a recommended order, not a final, but a recommended order back to FREC, in which they'll make the final decision on that recommendation. Okay. All right. Which statement concerning a consumer complaint is false? What do you think? Okay. You guys did good on that. That's very good. And that can be a real trick question, because if you read it too quick, the person named in the complaint must be a real estate licensee. You associate a complaint with a licensee, and so if you don't slow down and have an understanding that it's the unlicensed public can be filed a complaint against, you can see that the person named in the complaint must be a licensee, and that's false. You're absolutely right. It can be the unlicensed public. Very good. That's very good. Perfect. All right. Let's talk about proration. Everybody's favorite subject. When you prorate expenses, and basically what the term proration means is the buyer and seller have to split cost on the property at closing. Taxes, HOA, interest on the mortgage, all that stuff. Okay. And so the way this happens is when you prorate expenses, if they're split between the buyer and the seller, the state of Florida, the way they prorate expenses when it comes to real estate, specifically Florida, because every state has their own standard set of operations, SOP, standard of operations. on how they do their prorations. And so Florida, what you want to know when you do an actual proration problem, know that it's dividing what needs to be prorated. It's divided between the buyer and seller based on the act of sale. Okay. The day of closing always belongs to the buyer unless the problem says otherwise. Okay. So if the problem says that the day of closing belongs to the seller, and you knowing that it should belong to the buyer under normal conditions, if it doesn't say anything different, but the problem says it belongs to the seller, then that's going to tell you one thing. The seller is going to be charged one extra day, right? Because under normal conditions, the day of closing belongs to the buyer. But they tell you in the problem that it belongs to the seller, so that you know now that you're going to have to put one extra day for the seller, okay? The proration method, the 360 versus 365. 360 is another name. They call this is a banker's year. Okay, this is called a banker or a statutory year. Okay, and so the 360 method would be 30 days each month and 360 days for the year. Only use the 360 method if it's mentioned. Okay. 365 is what it defaults to. You're always going to use the 365 method unless the problem says otherwise. Okay. That's the days of the month to include February is 28. Actually, this year we're in a leap year, so it's 29 days this year. But on your state exam, unless they mention that it's a leap year, you're going to use 28 days. Okay. And it's going to be the days of the month. So January is 31, 28 for February, March 31, April 30, May 31, June 30, and so on. Okay. So days of the month you're going to use and 365. Always default to that, and the buyer gets the day of closing unless the problem says otherwise, which means if it does say otherwise, the seller's going to get one extra day. Okay. All right. The day of closing, and you got to finish it. What do you think? All right. Yeah, it's a tricky one. You're right. So this is, this looks like a simple question, but it's a little bit, you can fumble here. So here's what you got to realize. Okay. Let's go back and review. For Florida, when you're working this problem out, or if you get a theory question like we just got, the day of closing belongs to the buyer unless the problem says otherwise. So is the buyer always going to get the day of closing? And the answer is no. Okay. And we know if it belongs to the seller, there's one extra day charge for the seller. Okay. Normally, it belongs to the buyer, but the problem could say otherwise. So that means it's not always going to be the buyer. Okay. So if you come back and read this, the day of closing is always charged to the buyer. We know that not to be true. Okay. If belonging to the seller, it means the seller's charged one less day. We know that not to be true. Is always charged to the seller. We know that not to be true. If belonging to the seller, it means they'll get one extra day. We know that to be true. So you got to, again, this goes back to how you're going to read the question, right? And what you understand about it. You know that proration can be buyer or seller has the day of closing. So it can't belong to either one always. Okay. If it does belong to the seller, that means the seller is going to get one extra day. Okay. And always take this into account when you're working the problem. Okay. When you're working the math problem. All right. All right. This is a good section right here. Reimburse the broker who paid damages as a result of the EDO, which is called an escrow disbursement order. There's a term called legal effect under the 475 statute, right? Listen to me carefully. Legal effect is a term that says the public cannot sue the Florida Real Estate Commission. They're a quasi-government agency, and they can't be sued for doing real estate work. Public or not, let me take that back. They cannot be sued for doing Florida Real Estate Commission work. Okay. Remember, some of these are active licensees, so they can be sued for performing real estate. But if they're doing real estate commission work, they cannot be sued. One of the works that the Florida Real Estate Commission does and is in their line of duty, okay, besides being a PCB panel, is what's called an EDO, an escrow disbursement order. Remember, let me take you back to an initial part of a transaction. Let's say you're working with me. I'm a buyer. You're working with me. And I go out and we find a condominium and I like it and I'm putting an offer in. So we put the offer in. They accept the offer. Okay. The offer is accepted. And I give you a $5,000 deposit check and you bring it to your broker and it's deposited under the Florida 475 ruling under the law. It's in the escrow account, okay? Non-bearing interest escrow account. My $5,000 deposit lays. Now, about 3/4 of the way through the actual transaction, something's going wrong. I'm not liking what's going wrong. Not to get into details about the scenario, I want out of the contract. And I think I have grounds to get out of the contract. Contingency, let's call it a contingency. So you submit a cancellation and a return of the deposit. It's my deposit. And the listing broker of the condo says, no, the seller disagrees with you. They think they need a deposit. So now we have a dispute over the deposit. Okay. There is a dispute over the deposit. Okay. And so who's going to get the deposit back? Well, this is the responsibility of the listing broker now. Once a disputation has come about of the actual monies on who gets it back, the listing broker has 15 days, 15 days to notify FREC and 30 days to execute one of four duties to get the deposit to be worked out. Okay. It's 4. MALE, mail, mediation, arbitration, litigation, and EDO, escrow disbursement order. So my deposit's in the account. The broker comes and says, look, I'm going to execute per law the EDO, escrow disbursement order. I'm turning this over to the Florida Real Estate Commission, and they'll make the decision who gets the deposit back. I said, well, I can't argue with that. As a buyer, don't like it, but I can't argue with it because he's within the law to do that. And that's what he's going to do. He's not going to mediate. He's not going to arbitrate. He's not going to litigate. He's going to turn it over to the Florida Real Estate Commission called escrow disbursement order. Now the commission receives the case, and who gets the $5,000 deposit? Me or the seller? And so let's say, for example, the Florida Real Estate Commission says, it goes back to the buyer. And so I get my deposit back. Well, the sellers disagree with that. And so the sellers go to court and they're going to sue. Can they sue the Real Estate Commission for making that decision? And the answer is no, because of legal effect. They can't be sued. Okay. So who are they going to sue now? They can only sue the broker. Unfortunately, the broker didn't make the decision, but they cannot by law sue FREC. So they have to sue the broker. Listen to me carefully. This is the only time the broker can go into the recovery fund and not be suspended and get full reimbursement, attorney fees, court costs, all that stuff. Okay. So let's say that the broker was sued for $5,000. The broker doesn't have the $5,000. And even if he did, he paid it out to the seller. He could go into the recovery fund, recover his $5,000 and all the court costs, attorney fees to go to trial. Okay. So that's the purpose of what's called the EDO, or escrow disbursement order. Okay. That's where the escrow money is dispersed by the Florida Real Estate Commission, and they've made the decision who gets it back. And because it was a wrong decision in the legal system, and they couldn't sue the Florida Real Estate Commission because of legal effect, they sued the broker. Now the broker can go into the real estate recovery fund, get all the money back that he was sued for, plus attorney fees and court costs. Okay. So that's the big picture when it comes to disbursement of funds, which is deposits. Remember, the broker can go mediation, arbitration, litigation, or escrow disbursement order. Got a dispute between buyer and seller. I want my $5 back. Seller says, no, you don't have the reason to get it back. You're in breach of contract, whatever the case may be. But the decision is made by the broker to send it to the Florida Real Estate Commission and have them decide who gets it back under the EDO decision. They make the decision, wrong decision, gets it and wins in court. The seller wins in court, but can't sue FREC, but sues the broker. Now the broker can go into the recovery fund. Okay. So you want to know this big scenario and answer any question that can come about when it comes to reimbursement from an escrow disbursement order, how it applies to legal effect. Why does it? If you have an understanding of this, if you can visually see this, my goodness, you can answer 15, 20 questions if they ask you about it. Okay. All right. So here's the question. The broker followed the instruction of an EDO. The broker was later sued by a party to the real estate transaction. The lawsuit resulted in a civil judgment and the payment of $10,000 from the recovery fund. Therefore, the FREC, and then you got to finish it. There you go. Perfect. Right? The broker does not get any punishment, does not get suspended, and gets totally reimbursed. Remember, Florida Real Estate Commission is the one who made the decision, but they can't be sued. So the court case was won against the broker. Well, now the broker can turn around and get paid back from the recovery fund with no penalty, no suspension, or nothing. Okay? So we're talking about answer D. No action against the broker. No action. Okay. Back to administrative penalties. Remember, notice of noncompliance, first time events, usually a minor violation. Got to correct it. Okay. If you don't correct it, it could impose further discipline. We talked about the denial of application when it comes to someone who was denied an application to be processed. They got 21 days to file a request to be heard. They want to know why. Letter of reprimand, we said, is the least severe of penalties. Okay, minor conduct, not disciplinary. Suspension, 10 years. You got to know that. Revoke. Citations are 100 to 500. You got 30 days to make payment on those. And then the administrative fines, don't confuse citation with fines, is $5,000 per violation. Okay, $5,000 per violation. And then probation is, whatever they want to, but typically it's continuing ed, may have to attend FREC meetings, etc. All right, DBPR investigator is authorized in cases that involve a first-time offense of a minor violation to issue. Okay. There you go. Notice of noncompliance. And those are real small things. And the word noncompliance means you're not in compliant with something. Could be advertising, the required disclosures, etc. Okay, so it's minor. Doesn't require to go to the PCV panel and all that stuff. Okay. All right, listing agreements. You want to know these listing agreements: exclusive agency and exclusive right to sell or of sale. The difference is the word right. Let's look at that first. Exclusive right of sale means there's one broker that's going to sign the agreement to list the home. If the seller finds a buyer, the seller still has to pay the broker. You take the word right out and you got exclusive agency. Again, one broker. Now, if the seller finds the buyer, doesn't have to pay the seller or doesn't have to pay the broker. Okay. So the only one that's going to give guaranteed payment is exclusive right. So, which statement is true regarding the listing agreement? All right, let's look at answer A. Remember, we're looking for one true, three false. So answer A says exclusive agency listing provides the broker to earn a commission no matter who is procuring cause. That word procuring cause means who brought the buyer. Okay. And we said exclusive right is the only thing that protects the broker regardless of who brings the buyer. Exclusive agency, if the seller finds the buyer, doesn't have to pay the broker. Okay. So no matter who is the procuring cause is a false answer. So A is false. If required to effect the sale, the commission is only earned. You can only get paid if the property closes. So we're looking at answer B. Okay. Answer B. You're only paid as if the property is sold. Remember, exclusive right to sell, you're guaranteed. It doesn't matter who procures cause, who brings the buyer. Exclusive agency, if the seller finds, remember, you're missing the word right. If the seller finds it, doesn't have to pay the broker in an exclusive agency. Then they got one called an open listing. An open listing is many brokers. So you can have up to 5 brokers. Whoever brings the buyer or procures cause gets paid. If the seller finds the buyer, doesn't have to pay any of the brokers. Okay. The only one that guarantees and protects the broker to get paid no matter what is exclusive right to sell listing agreement. Okay. And that's what you're going to be signing when you go to work. There's not a broker. I don't think a broker out there that's going to sign anything less than that. All right. 3 phases of development. And this is from an initial process when we talk about new construction. Okay. So you got land acquisition. This is the developer. This isn't the builder. This is the developer. You got to acquire the land. You got to study the zoning. You got to get land use permits and you got to get all this paperwork and the legal rights to be able to build according to the zoning laws, etc. Okay. That's the land acquisition part. Subdividing and development. This is where they clear the land and subdivide it and they'll improve the raw land. We'll say it's a subdivision. Okay. Now, you have to know this term called concurrency. Okay. This is where we're bringing this to. Concurrency is a term they like to put on the state exam. This incorporates, I like to look at concurrency as what's called the infrastructure. Okay. I can't build a house unless I got roads going to it, right? No use in me building a house on raw land that I don't have any streets to go to the house, right? So I need to have surveyed lots made. I need to have streets. I need to have public utilities like water, sewer, electricity going to the lots. Okay. All that has to be incorporated. That's called concurrency. It's got to be approved by the government and I've actually recorded in public records. Okay. For subdivision. And it's usually annotated on what's called a plat map. Okay. Under the legal description, you got plat maps, meets and bounds, government survey, and lot and block or plat map. All these maps are pre-approved that are recorded in land records, and it's got the block number, it's got the lot number, it's got the subdivision name, and it's got all your utility layouts where everything's at. to include your streets, cul-de-sacs, and all that stuff. Okay. So that's called concurrency. Once all that is established, recorded land records, then the developer can sell lots to builders to put houses on. Okay. So the term concurrency is a very important term to understand in the 3 phases of development. All right. The requirement that the infrastructure for sanitary sewers, potable water, waste treatment facilities be in place before new development is allowed is the what? Okay. Concurrency is the term you're looking for. Beautiful. Perfect. All right. Florida Residential Landlord and Tenant Act. Now, anytime you see this term, this act, the Florida Residential Landlord and Tenant, this has nothing to do with licensees. These are individuals that are investors that are not licensees that manage their own property. Okay. Is that allowed? Absolutely. That's one of the exemptions of having a Florida license. If you buy and sell your own property, your deeded property, and or you manage your deeded property, you don't need a license if it's your own property. Well, they fall under not 475, not 61J2. They fall under the Florida Residential Landlord and Tenant Act. So anytime they're renting to military personnel, okay, renting to military personnel, the landlord approval when it comes to the rental application, within 7 days of completing the application, has got to give them an approval or a denial. Okay. If they don't, in other words, there's no answer back, then they must rent to the military personnel as long as they can comply with the other terms of the application. So 7 days is the military applicant's statutory limitation of getting approval or denial. Okay. And obviously, if it's a denial, there has to be a written in writing for the denial. Okay. So 7 days is what you're looking for. So the Florida Residential Landlord and Tenant Act requires landlords to approve or disapprove or deny the rental application. How many days? Okay. Excellent. Seven days. All right. Let's talk about licensed versus unlicensed assistants. Now, this is very important, a very important subject that you want to have a good understanding on, because one day somebody, maybe 2 or 3, maybe all of y'all, and I hope it does happen, you're going to come into the business and you're going to get so busy and you're going to fall into your niche market. You're going to start doing well to the point where you're going to have some type of help. And they're called assistants. And so they can be unlicensed or they can be licensed. Now, what you want to understand is what their capability of what they can do if they're licensed or unlicensed. Okay. If they're licensed, then basically they can do anything that you can do. Okay. So there's really not a problem. The only issue you have to know for the state exam when it comes to being licensed or unlicensed, if they're licensed and they work for you, you pay them for the work they do for you. If they go and sell a property, the broker's going to pay them the commission. Okay. So it's only work that's done with you for a licensee that you're going to pay them. It could be an hourly rate. But if they actually sell a property, the broker's got to pay them. Okay. And that's going to be the commission to the property. Now, individuals who are required to be licensed, this is kind of a list: leasing, sales of residential, commercial, and industrial, auctioning real property. You got to have a real estate license and an auctioneer's license. Assisting in the purchase or lease of mineral rights, engaging in business brokerage. Okay. Timeshare, unless you work for a Security and Exchange Commission company. like Wyndham. Wyndham Corporation has a big timeshare in Florida. Now, a non-licensed assistant can place signs in the yard for the agent, can upload data into the MLS, make changes into the MLS, can actually do marketing, write ads for the agent. Remember, all that's got to be approved by the broker. Any advertising, it's a broker's responsibility. Listen to me carefully, non-licensees cannot conduct any real estate activity with the public. So here's my question to you. Let's say I'm licensed, and I am, and you are my assistant, and you're not licensed. And I ask you to go do an open house for me. Open house. Can you do an open house for me? What do you think? Can you do an open house for me? You're going to open the house. Can you go do an open house? And the answer is no. You can't do an open house. Anything that you engage with the public when it comes to real estate activity, you have to be licensed. So if you're doing an open house, you're engaging with the public. Okay. You're out there. The public's going to come through. You're going to show them the property. You're going to talk real estate with them. You got to be licensed. Now, can you go with a licensee and sit at a sign-in table to make sure everybody signs in and keep the snack bucket full and the drinks bucket full? Absolutely, you can do that, but you cannot engage with the public, okay? You can upload data. You can change stuff in the MLS. You can go put yard signs out. You can't go to a home inspection for a licensee, okay? You can't assist a home inspector. It's only assistant work that's non-related to the public, okay? All right, a personal assistant must hold a real estate license to what? Okay? Yeah, you can fill out and submit listing changes. You can place signs in properties. You can write ads for approval, but you cannot conduct a listing presentation on behalf of a sales associate. You can't do that because you would be conducting real estate activity. Very good. I'm impressed. You guys are really knowledgeable. You know your content really well. All right, let's go back to sales associate education. Remember, here are the big two questions they like to ask. Listen to me carefully. 4-year degree or higher. You don't need to do any prerequisites to get your license except your biannual, which is the follow-on. You don't need to do the course. You don't need to do the licensing exam. You don't need to do post-licensing, only biannual. And the other one they like to ask is the course completion. Once you complete your end of the year, or excuse me, your end of the course with your school, okay, how long do you have to take your real estate exam with Pearson VUE? And it's 2 years. They give you a 2-year allowance from the time you finish your test with the school and you got your certificate of your course completion. You've got 2 years from that date until you have to take your Pearson VUE test, okay? 2 years. The other 2 years that's how long you got to be a sales associate before you go into the broker course, okay? Before you can get your broker's license. You got to be a sales associate for 2 years, okay? All right. A licensed applicant has completed the 63-hour sales associate pre-licensing course. Within what period after being issued the course completion slip for the pre-licensing course must the applicant pass the state exam? Good. Got 2 years. Perfect. Excellent. All right, let's talk about ethical practices. I'm going to start on C. I'm going to start on C with misrepresentation. And D. I want to talk about C and D first. Okay, pay attention, be carefully now, because this is really, there's about 2 or 3 questions that can come from this section here. Misrepresentation and fraud are 2 terms you want to know when it comes to ethical practices. Misrepresentation simply means what it is titled. You've misrepresented. It could be, and in most cases, the misrepresentation is, what's the word I'm looking for? It's not intentional, unintentional. Let me give you an example. If I'm taking a listing, in other words, I went out to a listing, signed the agreement, everything's good to go. I'm measuring the house and I calculate heated and cooled space, 3,500 square feet, a total 4,200 square feet. Okay. So total or gross is 4,200. Heated and cooled living is 3,500. I input that in the MLS. Buyer submits an offer. My seller accepts it. We're on the contract. It gets appraised. The appraiser comes back in the appraisal report and says the house is 3,200 square feet living, HVAC. 3,200 versus my 3,500 input. So we're 300 square foot off. That's a gross error. Very gross. Okay. So what happens there? Well, there's misrepresentation. It could lead to legal issues. Okay. It will definitely lead and can lead to what's called a voidable contract. So we could be, 6, 7 days out from closing. Everything else is complete. All the contingencies are exceeded. If I got out of the contract, or if the buyer got out of the contract, I could sue the buyer for specific performance or for liquidated damages. But in this case, because the appraisal came back 300 feet short, that buyer has been injured in this transaction and has by law and can be voidable in the contract and leave and get their deposit back. Okay. All because of misrepresentation, false or misleading statement. And again, unintentional. It wasn't intentional, but it could lead to serious damages. Because of that mistake, my seller may be upset with me because they got to be in another state starting a job in 2 weeks. And now they've lost this contract. So you can see how this can snowball. So misrepresentation is a very serious term when it comes to ethical practices. Now, misrepresentation, if it's done intentionally, becomes fraud. Let's say I measured the home and I came up with 3,200 square feet. And all of a sudden, I'm saying to myself, well, I'm going to put 3,500 in the MLS, but I know it's 3,200. Nobody will know, right? That's fraud. Okay, so misrepresentation is more unintentional. Okay, could lead to legal issues like we were talking about, but fraud is intentional. Okay, damages must occur to have fraud be a charge of fraud be brought on somebody. Okay, so misrepresentation and fraud kind of hitch together. Okay, now when it comes to culpable negligence, that's just a neglect of your duties towards your client. Okay, it could be from an act of misrepresentation. The culpable negligence is just a neglect. You're just not taking care of your clients. Okay. And then, of course, disclosure. You got to have the proper disclosures when it comes to the property, as far as the seller to the buyer, etc. Okay. Now, let's look at trick, scheme, or device. Remember, in the state of Florida, you have to have an auction license and a real estate license to auction off property. And those are the people that talk fast. You've seen the auctions. They talk real fast and people bid on the properties at an auction. Got to be an auctioneer. So you're licensed as an auctioneer, and you have a real estate license to auction off real estate. No one cannot sell lottery tickets. That's a form of auction. Okay. So no one can sell lottery tickets to the public for $100 a piece until they get the required money that pays the house off, where someone gets drawn from a container and they get a house transferred to them for $100. Okay. That's called trick, scheme, or device. Okay. So brokers cannot sell lottery tickets. The only time property can be in any fashion is auctioned with a proper auctioneer's license and a real estate license. Okay.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.
So you may see a question like this: a property owner and a broker decide to sell $20 lottery tickets to prospective customers for a chance to win the property. They announce that if 1,000 tickets are sold, the winning ticket will get the property free and clear. If less than 1,000 tickets are sold, the winning ticket will get the property for a price of $200 minus the value of the ticket. Which statement is true? Good. Charged with fraudulent and dishonest dealings by trick, scheme, or device. Okay, very good. Can't do that. You can auction off, but you got certain requirements to be an auctioneer, and that's again to have an auction license and a real estate license. Okay. This is illegal. Very good. All right. Let's talk about the Florida Real Estate Commission. What's the purpose of the commission? They're there to protect the public. Okay. Don't take offense to that. They're not against us. In fact, they're licensed themselves. But the job of the commission is to look out for the public, right? 7 members, 4 brokers, got to be active for 5 years as brokers. Okay. 1 broker or 1 sales associate got to be licensed for 2 years. So that's 5. 2 consumer members, which are non-licensees. That's 7. So you got 4, 5, 6, 7. Okay. 1 out of the 7 must be at least 60 years old. Okay. They're appointed by the governor, confirmed by the state senate. It's got to have a confirmation. They stagger their terms every 4 years, and the maximum is 2 consecutive terms. Okay. So basically 8 years. Okay. And the reason they stagger is just like any other government agency. You don't want to swap out a brand new commission for an old commission, right? Because they're going to sit around the table going, what do we do? So they stagger the terms. So they always have senior commission members that are running, that know what's going on to bring everybody up to speed, the new ones. Okay. 2 consecutive terms, 4 years apiece. $50 are their actual expenses they get paid for doing commission work. There's the term legal effect. You want to know that. They're exempt from civil liability while performing duties. They can't be sued. Remember, we talked about that in the EDO or the escrow disbursement order when the broker gets reimbursed. Okay. All right. Florida statute prohibits members from serving on the commission for more than okay. See, I would have wrote this. I would have put answer in there like 2 consecutive 2-year terms or 2 consecutive 4-year or 5-year terms or 3-year terms. I would have put in a little bit more, make it a little more confusing. All right. 2 consecutive 4-year terms is what the commission works. All right. Administrative penalties. Again, a nice review of this. A revocation of a license means it's permanently revoked. Revoke without prejudice. You may see this on the test now. This is where a license may be issued by mistake. They have to revoke it to reissue a new one, but there is no administrative penalty for it, okay, because there was no complaint. Remember, the applicant has 21 days to be heard why they didn't get their application accepted. We know about letter of reprimand, suspension, maximum of 10 years. Citations are 100 to 500, 30 days to pay them. 5,000 per violation on fines. Okay. And then notice of noncompliance, again, a first response to a minor violation, 15 days to correct the action. All right, an applicant was issued a sales associate license by mistake. She has been informed that the license has been revoked. Which applies? Very good. Excellent. Revoke without prejudice. Very good. All right, let's do another tax problem. Again, get a system in place to where you go through the numbers and how to unpack this when you get your tax problems. Okay, so so here we got the numbers. 8.1 is the county tax rate, 8.9, or excuse me, city is 8.1, county 8.9, schools 5 mills. The homeowner is a blind widow. Stop. That's where you got to, those are key words that you need to look at and say, 2 exemptions that'll total 10,000, 5,000 each. So you want to make note of that. You go to your scratch paper, you write that down. Home is assessed for 199,000. What are the taxes owed? So again, I'm going to break my city, county together. I got 199,000 minus 50. I get 25 plus 25, 50,000 minus 10,000. Blind widow, 2, 5, and 5. So I get 139,000 times 17 mills. I'm adding my mills together and moving to 3 places to the left. I get 2363. School tax. I only get 1 base exemption, 25,000 plus the 10,000 again for the blind widow for the school. So that's going to be 164,000. 5 mills times 0.005, $820 for taxes. And then I just add them together. Okay. So I'm talking about answer B, 3183. Okay. So if you just get a nice system, recognize, listen to me carefully, you need to recognize the additional exemptions, blind widow, disabled, etc. Okay. If you got more than one, combine the 2 5s together like we did here. It's a 10,000 total. Okay.
For more practice questions, videos, and insight into the state exam, we encourage you to join our free webinar, How to Pass the Real Estate Exam Without Your Real Estate Book and with only 15 to 20 hours of study time. Get registered now at myrealestatetutor.com/exam.